to continue talking about California evidence on page 17? No, 16. Testimonial evidence. Competency of witnesses. Both federal and California law require witnesses to testify based on personal knowledge and to take an oath or make an affirmation to tell the truth. In California, the witness must also understand their legal duty to tell the truth. That's often said in federal law, but in California, they're making that more clear. California safeguards for hypnotized testimony. A witness who has undergone hypnosis for the purpose of restoring memory is only competent to testify about matters that they recalled and related to others prior to the hypnosis. Additionally, in criminal cases, the CEC imposes additional requirements, including the substance. One, the substance of the pre-hypnotic memory must have been preserved in a writing or recording prior to the hypnosis. And two, the hypnosis must have been video recorded. And three, the hypnosis must have been done outside the presence of law enforcement, the prosecution, and the witness. Defense, I mean. Dead Man Acts. Some states have Dead Man Acts that make an interested person incompetent to testify to a personal transaction or communication with the deceased when such testimony is offered against the representative or successors in interest of the deceased. California does not have a Dead Man Act. So let's write that down. I just don't know where. Let's put it in a margin somewhere. No Dead Man Act. I'm not writing down the hypnosis thing. I can't imagine being tested on that. Okay, so refreshing witnesses' recollection safeguards against abuse. A witness may refresh their memory by looking at a writing. Federal and California law differs on a fairly technical point as to whether the adverse party can compel production of the writing. Under the federal rules, if the witness refreshed their memory while on the stand, the adverse party is entitled to have the writing produced at trial and to use use and introduce relevant portions, but the witness refresh their memory before trial, it is within the court's discretion to require production. In California, it is immaterial whether the refreshing was done before trial or during trial. If the opponent asks for the writing to be produced, the opponent must produce it unless they do not have it and cannot obtain it by subpoena or other means. Positions, please. So this I can put next to actually, I can't put that anywhere. Oh my god. On this side of the paper, this side, remedial measures are admissible in strict liability cases. Okay, these are pre-hypno acknowledgement. Oh, I did write hypnotism and right here. In California competency, you need to understand judge's discretion to sequester. Okay, so recollection refreshed, basically. I'm going to put it right here under hypnotism. So when writing is recollection refreshed by writing before or during testimony must be produced on request by opposing party. All right, so opinion testimony by expert witnesses, determining reliability. Under federal and California law, an expert witness's opinion must be based on reliable principles and methods that are reasonably applied to the facts. Federal and California law differ with respect to the determination of reliability of scientific opinions. Federal Daubert-Cumho standard is first written, and then California's Kelly-Frye standard is next. So federal courts apply the Daubert-Cumho standard. The court takes a flexible approach and can consider various factors when determining the reliability of scientific and non-scientific opinions, such as whether the expert's theory or methodology has been tested, whether it has been subject to peer review and publication, its known or potential error rate, the existence and maintenance of standards controlling its operation, and whether it is generally accepted in the relevant field. Kelly-Frye standard used in California. Is a general acceptance standard. And I think that's about it, hopefully, because I don't have a lot of room to write. The reliability of scientific opinions is determined by a single factor. The opinion must be based on principles that are generally accepted by experts in the field. So the opinion based on principles that are generally accepted by experts in the field. All right, and this standard is not altered by Prop 8 because it is a standard of relevance. Remember, Prop 8 only makes evidence admissible if it is relevant. Kelly-Frye does not apply to non-scientific opinions and medical opinions, the reliability of which is based on facts and circumstances of the case. All right, learned treaties, hearsay exception under the federal rules. Once established as an accepted authority in the field, the learned treaties that is relied upon by the expert or called to an expert's attention on cross-examination is admissible to prove any facts contained in the treaties. In California, a learned treatise is admissible only to show facts of general notoriety or interest found in published maps or charts or in books of history, science, or art. The takeaway is that this hearsay exception is very narrow and almost never applicable. Therefore, a learned treatise is usually admissible only on cross-examination of an expert witness. Almost never applicable, only on cross-examination of an expert witness. What did I write? I wrote, in California, a learned treatise is narrow, admissible only to show facts of general notoriety, or I don't know what that means. In notoriety or what? Interest is right. Used mainly in cross-examination of witness. Okay. Exclusion and sequestration of witnesses. Under the federal rules, if a party makes a motion to sequester witness, the judge must grant the motion, but must not include witnesses in the exempted categories. In California, the judge has discretion to grant or deny a party's motion to sequester, but must not exclude witnesses in the exempted categories. Impeachment and credibility and impeachment. Accrediting or bolstering. Under federal law, with certain exceptions, a party is not permitted to bolster the testimony of their witness until the witness has been impeached. And in California, the California rule is the same in civil cases, but in criminal cases, Prop 8 allows both the prosecutor and the defendant to bolster a witness's credibility before it has been attacked. Computer. Impeachment with prior inconsistent statements. When admissible as substantive evidence. A prior inconsistent statement is not hearsay if offered only to impeach. However, there is a hearsay problem when the statement is offered for the truth of the facts asserted. Federal and California law address this differently. The federal rules recognize a hearsay exclusion for certain prior inconsistent statements of a testifying witness. If the witness's prior inconsistent statement was given under oath at the trial or deposition, it is not hearsay. Otherwise, the statement is hearsay if offered to prove the fact asserted and inadmissible unless it falls into some hearsay exception. There are two important California differences. Prior inconsistent statements of a testifying witness are categorized as a hearsay exception, not an exclusion. And the exception extends to all prior inconsistent statements, even if they were not made under oath. So this I believe I have on the prior page. Need not be under oath in California. And there are exceptions to hearsay. Just for terminology's sake. The exception extends to all prior inconsistent statements, even if they weren't made under oath. Okay, next page. Impeachment with criminal convictions. There are numerous California distinctions relating to impeachment with prior convictions. The main considerations are what types of convictions are admissible for impeachment purposes. To make this determination, it's helpful to approach felony and misdemeanor convictions separately. Does the court have discretion to exclude an otherwise admissible conviction? Prior felony convictions. Felony convictions under federal rules. Under the federal rules, convictions for felonies involving dishonest or false statement, meaning crimes, fallacy, crimes like perjury, forgery, fraud, are admissible unless they are too old, as discussed below. The court has no discretion to exclude such convictions, meaning the court doesn't balance unfair prejudice against probative value. Convictions for felonies are not involving dishonesty or false statement are also admissible, but the court has discretion to exclude them. I don't know where this goes on my cheat sheet. Well, there's that. So these are previous felony convictions. Are at the court's discretion. I'm going to also write crimin's fallacy because I didn't think that felony convictions had to be crimin's fallacy. I thought they were treated two different ways, because crimin's fallacy might be misdemeanors too. So anyway, there's judicial discretion in California where for felonies not involving crimin's fallacy. Whereas I don't think there's judicial discretion on felonies or separately crimin's fallacy. So that's the difference, I believe. It's just the discretion element. Because there is discretion if it's crimin's fallacy misdemeanor. Or no. If it's misdemeanor, it would only be offered it was crimin's fallacy. So I guess that's the where the courts can use their discretion. But they wouldn't use their discretion against felonies. Okay, so let's just keep on going because That's one to double check on in federal. Now, the balancing test depends on who the witness is. For most cases, the courts use the 403 balancing test, but a different balancing test is used in criminal case where the witness is the accused. So that's all it says about that prior felony conviction section. Felony convictions in California. In California, all felonies involving moral turpitude are admissible, but the court has discretion to exclude them under CEC 352. Felonies not involving moral turpitude are inadmissible in California. Prop 8 does not make felonies admissible because felony convictions. I'm realizing now that everything I read prior to this was federal law. The court basically has no discretion to exclude crimin's fallacy, but may exercise discretion to exclude felonies not crimin's fallacy. Okay, that's what it is in the federal system or federal rules of evidence. But in California, you can never enter felonies that are not of moral turpitude. And the court has discretion for basically all felonies involving moral turpitude under 352 analysis. So I'm just going to write both, that and that. Are subject to court's discretion by 352 analysis. What's a crime of moral turpitude? It refers to crimes of lying, violence, but not simple assault, theft, extreme recklessness, or sexual misconduct. Crimes consisting of merely negligent or unintentional acts are not crimes of moral turpitude. Form of impeachment. The California Supreme Court has ruled on the form of impeachment with prior felony convictions in civil cases. The witness may only be impeached with the fact that they have been convicted of the felony, but in criminal cases, Prop 8 makes evidence of the circumstances underlying the crime admissible to impeach the witness if the proponent demonstrates that the evidence has any tendency to disprove credibility. So I'm going to page 26, starting with prior misdemeanor convictions. Just checking the time, we're at 17 minutes. Under the federal rules, all convictions for misdemeanors involving dishonesty or a false statement are inadmissible. Again, the court has no discretion to exclude these convictions for crimes of dishonesty or false statement. Convictions for misdemeanors that do not involve dishonesty or false statement are inadmissible. In California, it's a bit complicated and depends on whether the conviction is offered in a criminal or civil case. The CEC provides misdemeanor convictions are inadmissible. However, because Prop 8 convictions for misdemeanors involving moral turpitude can be admitted in criminal cases subject to the court's balancing and probative value versus unfair prejudice under CEC 352. That's actually a fragment. Because Prop 8 only applies to criminal cases, the CEC rule controls in civil cases, and this means that misdemeanor convictions are inadmissible in civil cases. So what's the case with misdemeanors of can be admitted? Okay. It's actually moral turpitude, not criminal's fallacy. Misdemeanors, I'm just going to say misdemeanors and felonies of moral turpitude and previous felonies, convictions at court's discretion by 302 analysis in crim, but never in civil, basically, unless I'm wrong. And the felonies can come in civil. Should I double check while I'm here? Sure, because I totally messed myself up by reading it in two different ways. What's the case in civil? Okay. California Supreme Court has ruled on the form of impeachment with prior felony convictions. In civil cases, the witness may only be impeached with the fact that they have been convicted of the felony, but the criminal case, okay, so it is, I'm just going to write, but misdemeanors are never in civil. They are in criminal. Wait, felonies are in. Okay. So my notes here are saying misdemeanor, moral turpitude, misdemeanor and felony is moral turpitude, and previous felony convictions at court's discretion by 352 analysis in criminal, but misdemeanors are never in civil. That's an idea. Page 23, older convictions. Under the federal rules, if a conviction qualifies for impeachment, but more than 10 years have passed since the date of conviction or release from prison, whichever is later, it's inadmissible. Unless the court determines that the conviction's probative value substantially outweighs its prejudicial effect. A tough balancing test to pass. California doesn't have a specific rule for old convictions. However, California courts always have discretion to exclude the conviction offered for impeachment under CEC 3C2, and this permits consideration of any factor bearing on probative value, including the age of the conviction. The competing federal and California rules for impeachment with prior convictions can be difficult to keep straight. If you're stuck, try focusing on the federal rules and try to remember the following important distinctions. California distinctions. To be admissible, the conviction must always be a crime involving moral turpitude. Misdemeanor convictions are admissible in criminal cases only. And third, the court always has discretion to exclude qualifying convictions. So those three things being all I need to know. I don't know why I didn't just write that down in the first place. 3 distinctions. Did you already memorize them? Court discretion, no misdemeanor in civil, and then the first one was moral turpitude. There you go. That's just like the highlight. You can read all the choppy sentence you just wrote. Impeachment with bad acts. Under the federal rules of witnesses, bad acts involving untruthfulness, in other words, acts of lying, can be admissible even if those acts did not lead to a conviction. The impeachment must be done on cross-examination only. Extrinsic evidence of the bad act is inadmissible, and the evidence is subject to 403 balancing. In California, the situation is similar to what we discussed with respect to misdemeanor convictions above. Impeachment with bad acts that did not lead to a conviction is permitted by the CEC. However, Prop 8 makes acts of moral turpitude admissible for impeachment in criminal cases. When admissible, both cross-examination and extrinsic evidence are permitted, subject to balancing under CEC 3D2. Because Prop 8 only applies in criminal cases, the CEC rule controls in civil cases, and this means that impeachment with bad acts is not permitted in civil cases. So I'm writing here bad acts can impeach in criminal, subject to 352, but and then for, or by, I should say, by cross-exam or extrinsic evidence. Next page, rehabilitation with prior consistent statement. Under the federal rules, a party can rehabilitate an impeached witness by introducing the witness's prior consistent statement. 1, if the testimony of the witness was attacked by a charge that the witness is lying or exaggerating because of some improper motive. If the prior consistent statement was made before the motive to lie arose. Or 2, if the witness was impeached by some other ground and the prior consistent statement to rehabilitate the witness tends to rehabilitate the witness. The California rule is the same with respect to Category 1, above improper motive, but is specific with respect to Category 2. A prior consistent statement is admissible if the witness was impeached with a prior inconsistent statement and the prior consistent statement was made before the prior inconsistent statement. Under federal and California law described above, a prior consistent statement for a testifying witness that is admissible for rehabilitative purposes is also admissible as substantive evidence for the truth of its contents. Under the federal rules, prior consistent statements are not hearsay. In California, they are admissible under hearsay exception. So I don't have this, and I'm going to write it down. Prior consistent statement is an exception in California, right? That's one. And then it's only available if to rehabilitate, right? If the impeachment was by prior inconsistent statement. That's it. I feel like that's all is different. I mean, yeah, the prior consistent statement has to be made before the prior inconsistent statement. Like, congratulations. Like, I feel like it wouldn't even qualify if it wasn't. So I got to page 26, which is hearsay. And I'm going to just read my own notes. What I have here is that ancient documents are greater than 30 years old in California, whereas it's much less in the federal rules of evidence. The prior identification statement is a hearsay exception rather than an exclusion. And something hearsay and requires that the identification occurred while fresh in the witness's mind. Witness confirms she made identification ID truly reflected witness opinion at the time, and the FRE and CA allows this as substantive evidence. I think that's one of the things I left out in the last part about bad acts. No. Prior consistent statements. Prior consistent statements can be substantive evidence. All right. The rest of the hearsay exceptions. Public records admit but not police report at federal, and in California it allows a felony conviction in civil and criminal, but only allows civil judgment if entered by plaintiff. Admission by party opponent is a hearsay exception in California. And what do I have? Party in case. Statement now against interest. California doesn't accept business record certification. Adoptive omission is a hearsay exception in California. It's not hearsay otherwise, like in the federal rules of evidence. Vicarious exception, equivalent in California. Dying declaration in California, declarant must have died and admit in all criminal and civil proceedings. Medical diagnosis hearsay exception limited to in California to statements when declarant minor speaking of child abuse, past, present, for diagnosis and treatment. So limited in, or not so limited in the timing of the statement, or the timing of the medical condition that the statement concerns. And then the past physical condition in California is statements made to anyone, not just medical personnel, concerning an unavailable declarant, past state of mind, emotional sensation, or physical condition is admissible whether that when the condition is in issue. A contemporaneous statement is one that's only in California. It's a hearsay exception. In California, a contemporaneous statement made while the declarant is engaged in conduct is admissible, and 2, to explain, qualify, or make defendant's conduct understandable. Now, California doesn't have a catch-all exception, and one of the things I didn't read so far was that CEC 403 means proffered evidence is inadmissible unless the court finds there is evidence, is what I wrote. Silly me. Let's see what else I didn't read yet. Remedial measures are admissible in strict liability cases in California. In California, observes the priest and penitent exception, at least. Recently, a proposition opposed it. It also recognizes journalist source, voter ballot, and trade secret. And I don't know what that says. Immunity? So voter ballot immunity maybe is what that says. And child abuse except to doctor-patient. Now, strictly adhere to settlement negotiations in admissibility, meaning that if you're negotiating a settlement, that any like culpatory statements are not admissible. California has no Dead Man Act. I wrote that down already. Best evidence usually allows duplicates, but no oral explanation without an excuse. California observes hypnotism. I talked about that. In California, competency to testify requires you understand the duty to tell the truth. I get that. I wrote that. I wrote down the Kelly Fry method, and sequestering witnesses, learned treaties, bolstering sufficient to sustain a finding of the existence of the preliminary fact. That compare that to FRE 103. Now, you can admit reliable statements about threats of physical injury when the defendant procured the witness unavailability. And no judicial notice discretion in California, and conclusive on both civil and criminal. That's what I have written in my cheat sheet, and so I'm going to probably read the rest of this in due course.